Good morning, everyone. I'm David Gregory, and thank you all for coming to the symposium. Before we get any further underway, I'd like to ask the Reverend Dr. Floyd Flake to come down and offer a prayer, a benediction, to bless our work here today. So, Reverend, if you would come forward and grace us with a prayer.
I did not know this was a part of the assignment, but good morning. I am happy to be here at St. John's Law. It's been many years since I was in a forum here, and I used to do more when I was wearing the title of Congress. But I guess after you get out of Congress, you don't have to come do these things. So if you invited me, I'm glad and happy to be here this morning. As he has asked me to offer a prayer to thee, God, we come with thanksgiving in our hearts, because we realize that all that we do is a part of fulfilling your mission for us as a people. And we honor you because you have blessed us with so many wonderful gifts, so many wonderful opportunities. Today, as we are in this place and we look across and see that there are people who have drowned in a plane, no one has an answer for what happened. We realize that there are so many people who have lost jobs, so many people who have not been able to find their way out of the cloud of darkness through the times of our financial crisis. But we know that you're God and you're still powerful. We know that things can be extraordinary when you desire to prove to us and give to us that which is essential for our lives. Help us on this day that as we leave this place, we're better than when we came. Our world is a better place because we have new thoughts, new ideas, new sense of correctiveness for those things that are wrong, and a sense of togetherness that helps us to be stronger as a people. In your name we do pray, amen.
Thank you, Reverend, so much. We have to make a few changes in football. They would call audibles at the line of scrimmage. Two of our greatest friends over the years, Cardinal Edward Egan, our honorary chair for the Labor Law Center, fell yesterday. His doctors have him in bed. He said, that's the last place I want to be, but he can't stand up. But he may still come through the doors, who knows? But he can't, so far as we know, as about half an hour ago, be with us. Bill Gould was in the White House with the Boston Red Sox and was then up to Boston, I guess, for today's opening game. His schedule is just too crowded, but he sends regards and regrets. But we have, for the university, I think our trifecta winner, my Vice Dean Emeritus Andy Simons. Mike Simons, the Dean, and the President of the University, Father Levesque, are on their way to Niagara University, upstate New York, for the installation of the new president there, Father Jim Maher. So again, regards and regrets. I'm not going to go through a long list of people to thank. I thank all of you. I thank especially my colleague and friend, Leonard Baines, who you'll hear more from tomorrow especially. And he's just a pleasure to work with. And the person who makes it all happen, always camera shy, but Paula Edwards, and I want to thank you for everything. This is Paula's the public face of the law school. People come to my office and say, where's the Labor Law Center? I said, go across the hall, you'll be looking at her. But thank you, Paula, for everything. That's about it from me for the moment. And so I'd ask the first panel to come on up and have a seat while my Vice Dean offers some welcoming remarks.
Thank you, David. Good morning and welcome. And it is such a treat to welcome such a group of distinguished luminaries from government, from the private sector, from law schools around the country. My name is Andy Simons. As David indicated, the dean cannot be here. He's on his way to Niagara. So that's his loss and my gain, because it's my privilege to be able to make welcoming remarks this morning. As David indicated, The title I have now is Vice Dean Emeritus. It's wonderful to have a little Latin in your title. Nobody knows what it means, and I don't tell them. But actually, I've had almost all of the titles that are available from the academic side and the administrative side in the law school over the years. But I may be acquiring a new one today because David said I have to fill in for His Eminence, Cardinal Egan. I've never had the title of Cardinal before. David said you'd be Cardinal in pectore, and I loved the Latin again, for a day. So I may have to modify my resume, which you have, by the way, and I'm not urging you to read it. It's way too long and boring. But I was thinking about my resume. You know, some people have troubles with their resumes by having things on it that aren't exactly accurate. I don't have that problem. But there's something that doesn't show up on my resume that I thought might be relevant today. David said I should make welcoming remarks because I was there. I had been in the Navy. I was in law school in 1963, 64, 65, when all of this was happening. And I have to confess, I wasn't there. I was here. I was in law school, and I was editing the law review, and I was immersed in what was going on in law school, paying not too much attention to what was going on in Washington. But that was not always the case. I graduated in 1965 and spent 2 wonderful years doing postgraduate work, clerking for Judge Adrian Burke on the New York State Court of Appeals. Mario Cuomo had also clerked for Judge Burke several years before that, and he referred to his 2 years with Judge Burke as the 2 happiest years of his professional life. You have to add the word professional if your wife is in hearing distance. And I shared that thought. They were 2 wonderful years in my professional life, and it was at the very beginning. Well, along comes the summer of 1966, and I find out that the Court of Appeals closes down for July and August. I go, well, that's great. What can I do during that period of time to make some money? I was making $6,200, by the way, a year, as a clerk for the court, and it went up to $6,800 the second year. So I'm in the summer. My wife and I have a little baby who's on his way to Niagara, as you heard. And so I'm trying to see if I can do some work and make some money. But I'm an employee of the Court of Appeals, and I'm still being paid by the Court of Appeals. I had to get permission from Chief Judge Fuld to get another position, which he was happy to give me, but it couldn't be with a law firm. It couldn't be with anything that might raise a conflict with the Court of Appeals. So who do I work for 2 months? The EEOC. Believe it or not, the new EEOC, which had just been created by the Civil Rights Act of 1964, I think his name was Bill Greenewald. He was trying to say, he was the New York administrator. He was trying to set up regional offices, and I helped him for 2 months, finding space, finding lawyers, doing things like that, enhancing my credentials to participate in today's program. And I knew you didn't know that. In fact, I reminded my wife of it last night, and she said, oh, yeah, that's right, I remember that. You worked for the EEOC for 2 months. It's my pleasure to welcome you. It's my pleasure to thank Professor Gregory, Professor Estreicher, and May Mansour, our student president of the Labor Law Society. David, I'm happy to tell you, you did not discover her. I did several years ago in torts. You're a Johnny-come-lately, but you appreciate really good talent. The 3 of them were really instrumental in putting together the program. As I turn it back to David, let's give them a nice round of applause. Thank you.
Thank you, Andy. And without further ado, we now have an epigram from the ABA president-elect for the conference called "Are You Kidding?" And the mystery will now be revealed. May's one of those characters who just sort of, her charisma fills the room. And you've been a pleasure to work with. You're a one-woman show.
I really don't deserve all of that, but thank you. Good morning. Thank you all for being here today and joining us. It's truly an honor to be among such a prominent group of people. When I was thinking about today, I thought back to a few weeks ago when I had an interview, and I was asked what I was doing in my capacity as the Symposium editor of the Law Review. so excited about the event. I started talking about it, and I enthusiastically said that I was helping plan the 50th celebration of the 50th anniversary of Title VII. So my interviewer paused, looked at me, and then laughed. Okay, awkward. And then he said, "I've never heard that. That is the strangest thing to say, celebrating Title VII." So I laughed along with him to move along the awkwardness, and I thought about it again later on that day. And I said, why was that so strange? If anything is worth celebrating, it would be Title VII. This is the anniversary of such a landmark legislation, the legislation that had finally recognized the rights of so many who had been previously denied the same recognition as their white male counterparts. The diversity of this audience is a true testament to how far we've come as a nation since the passage of Title VII. But I'm not naive, and while I do recognize that we've accomplished so much, I also recognize that there's still so much left to accomplish. So over the next 2 days, as we celebrate how far we've come, by looking at the past, present, and future of Title VII, we must not forget to recognize how far we have left to go. I look forward to the day when we can truly say that discrimination is a thing of the past. And while we are not there yet, I'm optimistic that we will be there soon. Before I end, I do just want to take a quick minute to thank our sponsors, the American Arbitration Association, the Asian American Legal Defense and Education Fund, the Latino Justice, the New York Civil Liberties Union, and the Society of American Law Teachers. And also, before I forget, I want to thank the hardest working women I know, and Professor Gregory did allude to one of them, but they do everything behind the scenes without much recognition. So I just want to thank Nancy Brady, Paula Edwards, Kristen Giuseppe Ferguson, Lori Hertz, Jennifer Manfredi, and Maureen Mulligan, and also the IT staff. And really, we couldn't have done any of this without you. And since I know you're all wondering what the mystery is and the answer to "Are you kidding me?", I did just have a baby on the 21st of March, but I'm here today, so thank you.
Everyone, when Professor Gregory asked for the panelists for the first session to come forward, you see how anxious I am. I'm the first one here. So we are ready to start our first panel. Welcome to the living history of Title VII, Voices of 1964 and Passing the Torch to a New Generation. Congratulations to David Gregory and to Len Bain for assembling this impressive panel and this impressive conference, and thank you for asking me to facilitate this morning's discussion. I'm sure for both days of the conference we will have a robust discussion. In June 1963, President John F. Kennedy proposed civil rights legislation that ultimately became the 1964 Civil Rights Act. Kennedy's decision was undoubtedly inspired by a decade of insistent civil rights activism. The images of civil rights demonstrators, beaten, assaulted with pressure water hoses, attacked by dogs, arrested, jailed, those images shocked Americans. Those images shocked the world. That summer, President Kennedy, Vice President Lyndon Baines Johnson, and Attorney General Robert F. Kennedy met with 244 lawyers. They asked the lawyers to use their skills and power to shift the struggle for civil rights from the streets to the courts. The meeting led to the creation of the Lawyers Committee for Civil Rights under law, and the committee urged Congress to pass the Civil Rights Act of 1964. But President Kennedy's bill stalled as activists and elected officials bickered about the details. So on August 28, 1963, 250,000 demonstrators marched on Washington. 3 months later, the bill was sent to the Rules Committee. That was the day before President Kennedy was assassinated. My parents marched on Washington on that sweltering August day. I know because they told me about it. I was just very, very small, I'm only kidding. I watched it on TV. But I want to tell you that they organized a bus for the church my mother still attends in Jamaica, Queens. In the 1960s, the focal point of civil rights activism was in the church, particularly the Black church, and the role of the clergy was salient. So we are honored to welcome Reverend Dr. Floyd H. Blake to the panel this morning. Prominent among the 244 lawyers who attended the conference with the Kennedys and with Vice President Johnson in that summer of 1963 were leaders of the state bars and the leader of the American Bar Association. Paulette Brown, one of our esteemed panelists, is the president-elect of the American Bar Association. So you see that the panel reflects the coalition building, the coming together of clergy and members of the bar that helped to ensure the passage of the Civil Rights Act of 1964. One of the tasks of the panelists this morning is to discuss the responsibility of many of you in the audience, the responsibility of new generations in continuing the struggle against employment discrimination. Vice Dean Emeritus Andy Simon's decades of service in legal education make him the perfect person to talk about this issue, and we're happy to have Andy Simons here with us this morning. Here's how we'll proceed. Each of the panelists will have 15 minutes or so to present their thoughts on this morning's topic. After these initial comments, the panelists will have an opportunity to respond to the other speakers, and I may have a question or two for them, and then we'll open everything up to the audience for questions. But I'd like to tell you a little bit more about this morning's first speaker, Paulette Brown. She is a partner in Edwards Wildman's Labor and Employment Practice Group and the firm's Chief Diversity Officer. Ms. Brown is the official nominee for President-elect of the American Bar Association, as I just mentioned. That is one of the world's largest voluntary professional organizations with nearly 400,000 members. Throughout her career, more than 35 years, she has held a number of positions, including in-house counsel to a number of Fortune 500 companies and as a municipal court judge. For the past 25 years, Ms. Brown has engaged in the private practice of law, focusing on all facets of labor and employment and commercial litigation. She has successfully defended employers in cases involving discrimination on the basis of age, sex, marital status, sexual harassment, disability, race, and national origin. She has received several successful results in class action unemployment discrimination cases based upon race, wage, and hour claims. And she's experienced in all aspects of workplace training and collective bargaining. Ms. Brown litigates in both federal and state courts, as well as arbitration forums for both unionized and non-union employees. She's a certified mediator for the United States District Court. Paulette?
Okay. Good morning. Oh, I can't hear.
Good morning.
Good morning. Thank you very much. Being from Baltimore, which is considered the South, if you haven't spent the night with the person before, you say good morning. Well, if you didn't live in the same household where you hadn't seen the person, you say good morning. And that was one of the things I learned when I first started working in New York, but that's a little later. But I think that it is most interesting, and I don't know that whether it was planned this way, but today is the 46th anniversary of the assassination of Dr. Martin Luther King. And it reminds me of a number of things, because it is someone with whom I grew up, didn't know him personally, but the one person we always recognized, and how we think about our priorities, and what Professor Wade just said about engaging young people and having them to remember how important Title VII and the Civil Rights Act is. And I'll just give you this one little story. My prom was the same day as the assassination, and there was discussion as to whether we should continue with the prom. Most people did not go, but it did continue. It did end early because of riots and so forth. But I'd just like to go back and talk a little bit about my background and how Title VII has had a really significant impact on me, as well as the Civil Rights Act of 1964. As law students, you probably have already researched the history and researched all of the politics that were involved and what Lyndon Johnson did to ensure that the law was passed, and how certain procedural issues were bypassed in order to get the legislation passed. And I won't go into a lot of that, but there were significant machinations went into it because there were so many people who were opposed to the passage of the Civil Rights Act. But I am a product of segregated schools. I am from Baltimore, which interestingly, people think that because it's so close to DC, that you would not have had such segregation, but it was a different kind of place. Baltimore was the South, DC was not so much. And so until through the 10th, 9th grade, I went to all black schools, had all black teachers, and I think I have to tell you, I think I am really good or better for that. I had teachers who absolutely cared about me. I did not have a sense of being disadvantaged, maybe in the 6th grade. When there was no 6th grade at my school, I was bused to another school that was segregated. But in the junior high school, it gave me an opportunity to be a part of an experimental program where I was in a class with the same people in every subject except foreign language for 3 years. And I believe that I know more about them than I know about the people who were in my high school class. And I think with very few exceptions, most of those in my junior high school class went to college. And so I did not feel disadvantaged. I feel really low too before, at all. But as time went on, obviously, Title VII created opportunities for me that I would not have otherwise had. But it also created some barriers, in a sense, because people begin to have certain perceptions of you, I think, as a result of Title VII, and thought that in every instance that you achieved a certain milestone because of Title VII and because of the opportunities that it afforded for people like myself. And that certain presumptions have been made because of Title VII. That is not to suggest that Title VII did not help me, because it did. Title VII was a vehicle that provided a somewhat of a level playing field, so that it gave people who were right thinking in some regards the freedom to select people who had not had certain opportunities. So whereas I did not feel disadvantaged by going to segregated schools, for example, I do remember some of the standardized tests that none of you would have in this, well, maybe a couple people, but certainly none of the students would have ever seen. And one of them I remember very clearly was that you had to choose which person was going to work. And the right answer was the white male with the briefcase. Well, I didn't know any white men, much less one who carried a briefcase. My father did not carry a briefcase when he went to work. He carried a lunch pail. And so obviously I would get that answer wrong. And so when you had things like that that sort of held you back and were the gauges of your level of intelligence, then you would automatically not be in the category where some others were. And so you needed Title VII to help you to get to that level playing field. So I am suggesting that Title VII was of a great benefit to me in that regard to have me to be able to demonstrate that I was as capable as the next person and given the opportunity to go to law school and to go to other service schools and then demonstrate what I was able to do once I was there is a great credit to Title VII. You know, when I think about some of the other things and my trajectory and going to the integrated school, not 10th through 12th grade, one of the reasons I was able to go there as well was because of Title VII. I was probably 15% black went to my school, and I chose that school because the superintendent of schools' children went to that school, and I thought that it would be an ideal situation. They had all the new bells and whistles and all sorts of things like that, but it was not an encouraging environment. It was a place where the guidance counselor, even though I was in college prep, constantly told me what I was not able to do, that I should not apply to a college like Brown, although the person sitting next to me in class was applying to Brown and should have applied to Brown according to the guidance counselor. And so because of his extreme discouragement, I was sort of left on my own, and I ended up going to Howard University, where I could not have been a happier candidate. And it instilled in me all of the rights that I had. Nobody specifically talked about Title VII, but people were aware of it. I had professors who had graduated from Howard Law School who were very well in tune to not just Title VII, but the complete history of Title VII. And so they instilled certain ideals and goals within me so that I could be successful and so that I could achieve. And so as time went on my career progressed, I was able to get into Seton Hall, and I would submit that because I did get into Seton Hall and that I did get a full scholarship, and I attribute it as a direct result of Title VII. No one again said Title VII, but it was because, really, the implication. See, when I asked about those time sheets, I thought that was from the report. But it has had, a tremendous impact. And now that I practice in the labor and employment area, although I represent management, I am always still looking for ways to counsel management in how they must not discriminate. And I have to say that I do work with some general counsels who are very interested in having appropriate workplace policies that will not discriminate against employees. Sometimes there are occasions where it actually happens, and usually it happens at the middle level, at middle management, as opposed to top management. And so those are people I find are the ones who are in most need of being educated with regard to Title VII because it does exist. And I think that you know that over time, Title VII has expanded with regard to certain protections that are afforded to individuals. I will close by saying that I think that Title VII is extremely necessary. I think that when we think about affirmative action, which is an outgrowth of Title VII, I think that we need to think about who has benefited most from this type of legislation and whether the people for whom it was intended are still able to get the benefits that Title VII was intended to provide for them. Thank you.
Thank you for sharing those poignant personal and professional experiences. They really help us to frame the discussion for this morning and for the entire two-day conference. Our next speaker is Reverend Dr. Floyd H. Blake. He is a former U.S. Congressman, and he is the pastor of the Greater Allen A&E Cathedral in Jamaica, New York, with over 23,000 members. Until June 30, 2008, he concurrently served as president of Wilberforce University in Ohio. During his 37 years as pastor, Allen has become one of the nation's foremost Christian churches and development corporations. The church and its subsidiary corporations operate with an annual budget of over $34 million and also own expansive commercial and residential developments. They own various social service enterprises. While continuing his responsibilities as pastor of Allen, Reverend Flake served for 11 years in the U.S. Congress, that was 1986 to 1997. Reverend Flake authored a best-selling book, The Way of the Bootstrapper, 9 Action Steps for Achieving Your Dreams. He and his wife, Elaine, co-authored the book Practical Virtues, Everyday Values and Devotions for African American Families, published by HarperCollins, and his latest book, The African American Church Management Handbook, published by Judson Press, was released in December 2005. Welcome, Reverend Flake.
Thank you. I'm grateful for this opportunity to come and be a part of this panel. I am a product of the era, just as Paulette is, that preceded the era that we are a part of today. And so my historical background, I come from Houston, Texas, family of 12 children, and we lived in a house that did not have any toilet. Some of you may know about that experience. It's not an experience you would like, especially since you had to go out in the dark at night, and it was challenging. My early years, my mother and father, without an education, because they had to go in the cotton season, they had to stop doing whatever they were doing in order to go and pick the cotton and to do all the things that were required of them just to make a living for the family. It was not a means of a great deal of income, but with that and with what my father did in his job, which was working in a tile industry where they made tile, where they had asphalt. They did not have the laws governing asphalt at that time, and we believe that even my father's death was not necessary at the time that it was, but because he had been in this plant all those years. My schooling was getting on a bus in the morning, going 30 miles, past 3 white schools, and out into the country, an unpainted building, a building without outdoor toilets. Imagine that, with about 60 kids, 60 students. But we had teachers who had designed within their own fabric of themselves that they were going to make sure that every child got a good education. That brought most of us to a place where we believed that we could be better than what other people thought we were, We could achieve well above the limits that they had placed upon us. We believe that in spite of the fact that we did not have the things that others had, that we could indeed achieve. The books that we received were books that had been used by white students. They were dirty. They had no place for us to put our name in the book because they had taken all of the lines in the book themselves. It was a season when, in spite of what we were going through, we did not allow ourselves to get to a state of misery where we did not believe we had competencies to achieve. Our teachers taught us, and in my case, my teachers that taught me in school were the same teachers who taught me in Sunday school. And so we were trained every single day of the year. One of the things that I found difficult was when I got to the place where I wanted to go to college. And I was trying to decide whether I was going to take the track scholarship to Texas Southern Prairie View. And then made a decision that I wanted to leave the state of Texas because I thought it would be better if I went up north. So I wound up in school, Wilberforce University, the first African-American university in the country. And so when I got there, I came to the realization that the only way that I would be successful is to drive myself in a way that allowed me to understand the kind of culture I was functioning in, but also to understand who I wanted to be ongoing. And at Wilberforce, I came to the president's office on the first day, didn't have money, but my mother was great. She taught me how to cook, wash, iron, and sew. I can clean anybody's house, so I may put a sign up before I leave, so need a little extra because I got these 4 children in this vanguard. But I learned how to do it. I went to the president's office and I told him I was here. I didn't have any money. I got on a Greyhound bus, came all the way up from Houston, and I got to Ohio. And he said, well, what can you do? I said, I can cook, wash, iron, and sew. He said, well, go to the cafeteria, tell the cafeteria person that I sent you over to get a job. So I started out, obviously, the pot washer job and the kind of job that you could get at that time. But it was a lesson for me because I am probably one of the hardest workers that I know anywhere. And because I had that opportunity, I took full advantage of it. By the time I got out of college, things were different. Martin Luther King had gotten killed on the term that I was in college, and obviously most of us who were students from Wilberforce, Central State, which is across the street, and Antioch College, got together, got on buses, went down south, went down to North Carolina, sat in front of the stores where the lunch counters were. And I assumed at that point that we were moving in a positive direction. Things were going to change relatively quickly. They did not change as quickly as I thought they would. And so by the time I got to Boston, and I was dean of students first at Lincoln University and then dean of students at Boston University. By the time I got to Boston, I thought things certainly were going to be better. But I discovered that after Judge Gary issued his statement and had all the schools in Boston integrated, that was a battle. Those persons who were priests who got on buses with us and went to North Carolina would not come out of their sanctuaries, out of their churches, and speak to their own people. And their own people were throwing rocks against the buses where the children were trying to get educated. We could not get white parents to cooperate in any way. As some of you might know, they had to have Judge Gary's decision to force them to integrate. I have seen the best, I have seen the worst. I have seen battles that should not have happened. I've seen people's lives hurt. I think often about Emmett Till, who, when I was a child, Jet Magazine, which is a black magazine, had to look at the picture of this child laying in a casket with his face smashed in, had to think about people like Medgar Evers, killed in his front yard because he dared to ask African American people to follow him and to vote. The challenges were not easy, and getting a job was almost impossible. But the reality is, I came to the conclusion that it is not what they think of me, it is what I think of myself. Do I believe that I have within myself enough capability that I can overcome the barriers that are constantly confronting me? And I am constantly teaching that even today, because our young people are in a place where, if you look at the school systems, if you look at the graduation rates, especially with African American children, right here in New York, graduation rates for African American students is about 32%. And Latinos who have come to our country and learned the language and gotten themselves to a full understanding of what it takes to function in an environment like this, graduating at about 62%, and Asians at about 75%. So the challenge is still here because our young people are still facing, even with Title VII, they're still facing challenges that they ought not be facing at this time in this generation in which they are living. The challenge becomes one of us having to take personal responsibility, regardless of race, creed, or color, to focus on a reality where everyone has an opportunity to be their best self. Everyone has an opportunity to get their best job. Everyone has an opportunity to get into the best colleges and to do what is essential for them to have the kind of lifestyle that is compatible with the majority of America. And it does not happen. As we look at the culture today, as we look at the communities today, I began building houses back in 1978, and I began to build homes because I realized when I came to Jamaica at 29 years of age, 38 years ago, that this community would fall apart if we kept allowing it to continue to function in the way that it was. And so I got to the mayor's office, managed to get permission to build houses on empty lots, built the first 144 homes, 2-family homes. I did not build single homes because I wanted the owner to have an opportunity to have someone to help pay for it, so I put rental units in every house. That first 144 units, by the time we got the Congress, I had built 400 homes. 5 minutes, very close. Are you in a church somewhere? but what I learned in that was it is essential to have good communities, good family structures, and that is one of the things I think Paulette will agree with me that we are struggling with as a people. But those family structures are not necessarily because people don't want to work. It is because they're not given opportunities to the kinds of jobs that helps them to raise their children in an environment where they're able to succeed. We're still far behind the curve, even with Title VII. There is so much more we need to do. There's so many more challenges we have, and I don't think change is coming. Having been in the Congress, I am thankful to God that I'm not there now. It is an entirely different kind of environment. When I was there, at least Republicans and Democrats could get together. I think the record will report that I put 2 federal buildings in South Jamaica, 2 federal buildings. No one has done that in the history of the Congress. And I did it because I also collaborated with my colleagues on the other side of the aisle who were Republicans. Our challenge is to come to a point where we dare to believe that together we can do more than we can do if we fight and move in different directions. I do believe that the greater America has not yet been seen. I believe that we're still moving toward a level of greatness, but I do believe that we learned many lessons from our current president, that there are just many people who just don't believe that people of color have the temperament, the capabilities, the competencies, and the skills to be able to manage. If others can do it, I dare to believe we can do it, and I believe that America will be greater. Hopefully in my lifetime, I'm 69 now, so I don't have much time left. But I'm hoping that it happens in my lifetime so that my grandchildren's children will not have to go through any of the changes that I've had to go through in my life. I think that this is a good forum. It is an important forum, and it should not be viewed as just another event. I believe that all of you, and I think many of you are probably here in law school, you can help to change the dynamic of this society, the dynamics of this culture, and make this a better place for everybody to live. Thank you very much.
Thank you, Reverend Flake. Your comments really provide vivid historical context for the times in which the Civil Rights Act was passed. Our next speaker is Dean Andrew Simons, Vice Dean Emeritus Andrew Simons. He currently serves as the Vice Dean here at St. John's Law School. Since returning to the law school in 2000, he has served in a variety
Well, you're not going to read that whole thing.
capacities, including associate academic. I know you need no introduction, but I'm going to introduce you anyway. He chairs the law school's strategic planning committee. He teaches sports and New York civil practice. And you're raring to go, so go ahead. That's all I'm going to read.
Thank you so much, Cheryl. And by the way, Dr. Flake, I did with you, 69 is young from my perspective. I am getting more and more accustomed to being the oldest person in the room. But first of all, I'd like to say what an inspiring experience it has been for me to sit between Ms. Brown and Dr. Flake and listen to their comments and their experiences. I hope you all realize what a special occasion this is. And in thinking about it, I want to talk a little bit about the history of the Civil Rights Act and how it came to pass. But I was thinking, in reflecting upon the assassination of Dr. King, which we commemorate today, I thought, I teach torts, and I know there's some other torts teachers here in the audience. There was another very significant development in the law in 1964 in addition to the passage of the Civil Rights Act. And that was the Supreme Court decision in New York Times against slavery. And we think about that as being a defamation case in which the Supreme Court put a constitutional gloss on the ability of public officials to recover in defamation cases, but we don't frequently think about the genesis of that case. It arose out of the civil rights demonstrations in Montgomery, Alabama. And a group of civil rights activists, black organizations, and others took out an ad in the New York Times seeking to raise money to support the civil rights movement. And there were some inaccuracies in the ad. And Sullivan was the commissioner of Montgomery County who was responsible for the police department. So he brought the suit, Sullivan against New York Times. He wasn't mentioned in the ad, by the way. They could have thrown it out on that basis and saved us torts teachers a lot of time and effort. But he, of course, recovered. He recovered a very large judgment from a jury in Alabama. The jury, the all-white jury, by the way, was followed every day to and from the courthouse and their home by white vigilantes. It was clear what their verdict was going to be. And it went all the way up to the Supreme Court of Alabama, where it was affirmed. The misstatements in the ad, by the way, were another basis for the court to throw it out. They said Dr. King had been arrested 7 times and he only been arrested 3 times. They said the student demonstrators were singing America the Beautiful, and in fact they were singing My Country Tis of Thee. It was literally misstatements like that that Sullivan claimed defamed him, and it took the Supreme Court to change the law of defamation to make sure that he couldn't recover. Just an interesting observation. I wanted to find out what people would learn about the Civil Rights Act in 1964 if they Googled it today, and if they went on Wikipedia. And Dr. Flake, you'll be interested to know that you're dead wrong. Apparently all of the problems of discrimination have been solved. Because here's what Wikipedia says. The first sentence is accurate, the second sentence is suspect. It says the Civil Rights Act of 1964 is a landmark piece of civil rights legislation in the United States that outlawed discrimination based on race, color, religion, sex, or national origin. Fine, so far as it goes. It ended unequal application of voter registration requirements and racial segregation in schools, at the workplace, and by facilities that serve the general public, known as public accommodations. Isn't that interesting to find out? And I compared that, I started reading this, and I was reading last Sunday's Times, in which the front page article was entitled, "New GOP Bid to Limit Voting in Swing States." Here's what they said. Pivotal swing states under Republican control are embracing significant new electoral restrictions on registering and voting that go beyond the voter identification requirements that have caused fierce partisan brawls. The bill's laws and administrative rules, some of them tried before, shake up fundamental components of state election systems, including the days and times polls are open and the locations where people vote. Democrats in North Carolina are scrambling to fight back against the nation's most restrictive voting laws passed by Republicans there. So I guess it's not over yet. Wikipedia, to the contrary, notwithstanding. I wanted to reflect a little bit on President Kennedy and then Vice President Johnson, who became president. President Kennedy had all of the eloquence you could wish for. He really was an inspiring leader. He didn't necessarily have all of the wily and crafty smarts that Vice President Johnson had in terms of getting bills through Congress. You have to remember that Lyndon Johnson was the majority leader of the United States Senate for many years. He was the expert craftsman on getting bills that he wanted through Congress, or not getting bills through Congress that he did not want. And Lyndon Johnson wanted nothing about being Kennedy's vice presidential candidate. Why would he want to give up being one of the most powerful men in Washington to become the vice president, one of the least powerful people in Washington? The elders of the Democratic Party apparently prevailed upon it in 1960 for the good of the party to blend the Massachusetts senator with the Texas senator. I can assure you they spoke differently. They sounded different. Johnson was a good old boy with a nice southern accent as opposed to the Massachusetts brash young senator. And together, they were able to squeak out the election and got elected. And Johnson faded into obscurity for 2.5 years. Here's what Kennedy said in 1963. Now the time has come for this nation to fulfill its promise. The events of Birmingham and elsewhere have so increased the cries for equality that no city or state or legislative body can prudently ignore them. He was such an eloquent speaker. Notice how he used trilogies all the time. We face, therefore, a moral crisis as a country and as a people. It cannot be met with repressive police action. It cannot be left to increase demonstrations on the streets. It cannot be quieted by token moves or talk. It is a time to act in Congress, in your state and local legislative body, and above all, in all of our daily lives. Next week, I will ask the Congress of the United States to act, to make a commitment that it has not fully made in this century to the proposition that race has no place in American life or law. Very eloquent. 8 days later, on June 19, 1963, Kennedy sent the comprehensive civil rights legislation to Congress. There was little likelihood of its passage. Professor Wade referred to that. And by the way, Professor Wade, I do have a bone to pick with you. Next time when I'm on a panel of 3 speakers, like I'm sharing with, I don't want to go third. The last thing I wanted to do today was follow the eloquence of our first 2 speakers. That's for next time.
Just being hospitable to our guests.
I also, of course. Little humility is a good thing. My uncle was a dentist priest, and whenever we beat him in cards, he would always say, "I prayed to Mass this morning for humility, but this is overdoing it." Little humility is a good thing. So while this was bottled up in Congress, Kennedy gets assassinated in November of 1963. And Lyndon Johnson, this Machiavelli from Congress, not noted to be a civil rights mover, becomes president, and he embraces Kennedy's desires. Here's what Johnson said. We have talked long enough in this country about civil rights. It is time to write the next chapter and to write it in the books of law. And he says this with his nice Texan drawl. No eulogy could more eloquently honor President Kennedy's memory than the earliest possible passage of the Civil Rights Bill for which he fought so long. We're familiar with all the machinations that were on in Washington a couple of years ago regarding the passage of Obamacare. That was nothing compared to what went on in 1963 and 64 regarding the passage of the civil rights. I'll mention just a few of the prominent politicians. Representative Howard Smith, Democrat of Virginia, was chair of the House Rules Committee, and the bill was going to come out of the Rules Committee over his dead body. Senator James Eastland, senator from Mississippi, was chair of the Senate Judiciary Committee where the bill went in the Senate. Senator Richard Russell, Democrat from Georgia. Senator Strom Thurmond, Democrat from South Carolina. Senator Robert Byrd, Democrat of West Virginia. There was no way that Kennedy was going to get this bill passed. And then Johnson becomes president. And he has all of these skills, he has all of these obligations, all of these debts, and he knows how to deal with Congress. And lo and behold, 1964, the Civil Rights Law is passed as we know it today. And the EEOC is created, for which I spent 2 months at Chairwoman Berrien as in his gainful employment. The title of this program today is The Living History of Title VII, The Voices of 1964, and Passing the Torch to the New Generation. My fellow panelists clearly span both generations. I am clearly a voice of the past, and I look forward to hearing the voices from the new generation. Thank you very much.
Thank you. Could I just start the question and answer period by just asking Ms. Brown about her work at counseling management on how not to discriminate. I teach here at St. John's. I forgot to tell you that I'm one of the faculty here at St. John's Law School, and I teach corporate governance and business law and race and gender seminar. I'm an employment discrimination lawyer. I'm not a civil rights lawyer. I've never practiced in that area. I did practice corporate law. And so I have looked at some of the issues about which the panelists have spoken today from a planning perspective rather than a litigator's perspective, and am concerned about how to get employers to treat employees in a way that will not lead to discrimination or to litigation, discrimination litigation. So I'm very interested in hearing your comments on some of the counseling you do with management. I'm a little cynical about it because I wonder, well, not about your counseling, but employers' responses, because some of it seems a little cosmetic and like window dressing. And one would hope that after 50 years, after Title VII, as we celebrate Title VII's anniversary, that there would be more structural changes that would avoid litigation.
Okay, so let me just start by saying that because I was considered a radical in law school, when I started doing employment work on the management side, a lot of my friends told me I had gone to the dark side. But you know, there are opportunities to be helpful to employees when you represent management. And some of the things that management put in place are certain policies which would deter discrimination. And for example, means by which an employee who believes that there has been some discrimination committed against them to have a procedure for reporting, a procedure for remediation, a procedure for discipline for those who have discriminated against, who have been discriminated against. And one thing that Professor Wade and I talked about earlier was the issue concerning diversity and inclusion and Title VII and discrimination. And I think that, you know, she talked about how people talk about diversity kind of more now than Title VII. And I think that personally it is important to talk about that because if you have an effective diversity and inclusion program, it goes beyond the protections of Title VII. And what I sort of counsel people is that, you know, let's not just look at it from a legal standpoint, but from also a diversity and inclusion standpoint, because the parameters of, for example, a disparate impact test when you're doing a mass layoff, for example, you can, you know, eliminate certain positions and certain groups of people, but you will lose still your diversity and inclusion. So I think that people should look beyond Title VII in that regard. But I think that, you know, employers who offer trainings on what and what not to do in the workplace is extremely important, as well as having the policies in place and enforcing the policies. Enforcement of the policies are extremely important. You know, in New Jersey, we say that there is every law imaginable that protects employees. And the plaintiff's bar says that New Jersey laws are horrible, but I can assure you they are very, very, very protective of employees. And so when you live, for example, in a state like New Jersey, you don't even have to be an employee to be protected by discrimination laws involving employment and public accommodation and the like. So, you know, the best thing that we do, you know, because the laws change, things get added to the law on a regular basis, is to instruct employees as to what they should do, not just at the higher levels again, but as I mentioned before, a lot of the discrimination happens at the mid-manager level because they believe that they can do things the way that they want to in the interest of the business, and in quotes. The other area happens with smaller employers who just are not aware of many of the laws in place and think that this is a family business. We can say what we want. You know, it makes me cringe. You know, even now, I, you know, was meeting with a client, small employer, and they refer to the women, talk to the girls out there. I'm like, really? And you know, and I've gone into small employers where people will still have calendars with pinup girls on them. That's even now. And so, you know, I always like to visit the place of the employer so that I can really see what's going on. I don't like to just talk to them, so that you can see any underlying issues and you counsel them immediately on things that you observe and things that are going on and that they should not be doing those things. Thank you.
And Reverend Flake, a question for you. I want you to, if you can, speak to how the church's role in the quest for civil rights has changed. I know that your church is focused on economic development. I think that maybe it seems as though it's a new development, that kind of focus, building homes in Jamaica, Queens as a way of community development is important work. But I want to know if you could speak to the role of the church in general with respect to civil rights.
Yeah. Well, I think from the perspective of Allen Church, it is kind of uniquely different from what most churches do. And it is that in part because I come from corporate, so that my church does not run like a church. My church runs like a corporation because I understand that it is a business. And so the differential between where I am and where the majority of my colleagues are is centered around a sense that you have that churches still have a full responsibility for every aspect of the life of the people that it has responsibility for. So that for a church like mine, we have our school. We have our school because we understood when we came here, my wife was teaching in Boston, I was at VII, and we made a decision that we are going to educate. Once I saw what the educational variables were here, that we were going to educate these kids in this community. And so I think that, biblically, we go through this whole thing about social justice. We talk about social justice. The problem for me is I'm not sure that I can define social justice within a context other than the language of it. And our problem is we spend so much time on the language of social justice, we don't get things done. So for a church like Allen, what we do is there is elements of there are various ministries and entities that touches almost every single thing you can imagine. So that whether it is having a sector that we call our young adult ministry, and that's young adult people who, many of them are right down on Wall Street and places. We've sent them to college. They've come back because they feel they're rooted here. And then we have that segment that deals with those areas that relate to schools. We have job training on site. We have just about anything you can imagine that is a need. We have identified it. And then I have ministers, staff ministers, who have responsibility for it. So it's quite a different kind of model, but I do believe that it's a mini model. Many are copying the model because they come to realize that it strengthens your church when you're doing more for people than you ordinarily do. It cannot be just a Sunday morning sermon. You can't build it around it. So my church, according to the state, is the largest congregation, number congregation in the state, but it's because people know you are getting something out of it when you come, and we are building the life of our children, we're building the life of our people, we're protecting the life of our senior citizens, and we're protecting those people who cannot do for themselves what is necessary for them, even to go out on jobs. Tuesday night is packed. We have people in there and we're trying to find jobs for them. So the church is no longer this biblical scenario that just comes and opens up on a Sunday and closes Sunday evening and opens up for Wednesday night Bible study. And I think the modeling has to be shifted to a degree because we are talking about yesterday's civil rights as opposed to, if you go to any march, any protest, we talk about yesterday's civil rights. We are still not in line where we are focusing on what's our next steps. We've gotten this far. We know what Title VII is, but what's the next step? And the generation of our children are not getting the benefit of that. And I may be off, but I certainly would welcome any comments.
Oh, well, you go.
He's right on.
He is, absolutely correct. And one of the things that, I see as an issue with younger people, especially those like my son and maybe your children, who have not had to experience some of the things that we did, is that they believe that all is well in the world. They didn't have to take loans for college and things like that. They think all is well in the world and that the Wikipedia is correct. And that should let you all know that you should not use Wikipedia when you're doing your research. But, and so, I think that, when they, sometimes it's not until they reach the job market that they have a rude awakening that Title VII has not really come into its own as of this point in time. And it has not, because there's still many, many, many challenges that still exist, and even, and as you go along, it thins more and more. And things are still stagnant in many areas. When I was introduced, you heard them say that I am a partner in a law firm. Well, I will tell you that for the past 20 years, women of color have been 1.8% of partners in large law firms. It is still 1.8%. And so, I mean, that is a clear demonstration that something is not working as it should be. So, you know, no one should feel any false sense of security or feel that because now that as a result of Title VII, you can go to certain schools, you can go to the best schools, that these issues are still not in play. They are very much in play. And there are still many people, even though you have gotten the best education that you can possibly get, there's still some people who believe that because of their sometimes conscious or unconscious biases, that that you got there somehow as a result of Title VII or some affirmative action program, that you don't have the necessary gray matter that you need. And by the way, for all the women in the group, you know, gender was an afterthought in Title VII. And so, but you know, a lot of women have benefited, but it's still, you only represent 17% of partners in law firms. And so, you know, you have this massive number of people where...
And 50% of law graduates.
Exactly, that's right. So what happens if there's not some failure in Title VII that causes it to go from 50% to 17%? And that's the average, which means there's a lot more. Sorry, I took so long.
No, we enjoy listening. We have time for questions from the audience, so let's open it up now with those questions. Rosemary?
Thanks, Cheryl. Thank you, panel. I just want to commend Ms. Brown for bringing out the more subtle issues in Title VII. Having served as an expert witness on sexual harassment cases in higher education, I think that makes it very crystal clear that it's very hard to prove a Title VII case. There's the more subtle forms of discrimination. And I admit that the Civil Rights Act was really, the force of it was really to bring equality to African Americans. There's absolutely no doubt about it. But somehow sex got in there almost as an accident. It did. And it has benefited women in many ways. But in your working with management, and you're sniffing around, looking around to see, are there pictures of pinups, or are the women referred to as girls? Do you see a lot of that?
I see it more in smaller companies, not in the large corporations, because I find that many of the large corporations, the ones I represent anyway, they are very strict in their discipline with regard to what they see, and mostly overt acts. But as you say, there's so many subtle things, so many things that, you know, so many micro inequities that happen, you know, little snits of things that people do that maybe the person next to you wouldn't necessarily recognize, but you know, and the person who's dispensing the micro inequity knows it. And to me, that's a form of discrimination that is not necessarily recognized. So yes, those things sort of happen. You're not being recognized as a person who gives the great idea and later does not get credit for it, and therefore you don't get the raise as a result of the great idea you had when the man next to you then says the same thing and gets the raise. So to me, those are, you know, discrete, subtle acts of discrimination that continue to happen in the workplace. Sorry to say, but it's the way it is.
I had a chance to do some research with an employment discrimination law lawyer focusing on some structural change and the changes in corporate governance. And so I traveled with him to do this research with him and his team. And I had the opportunity to travel to Paris, Texas. So, and I went to a trial. I attended a trial where the plaintiffs discussed and it was very rare to go to trial, but they discussed some of the discrimination they face. And these are facts that unfolded not in the 20th century, but in 2012 and 2013. And so what I heard from the plaintiffs and what I hear from him month after month, I'm still working on this project, and he talks about new cases, are horrifying stories, not just of discrimination in hiring, promotion, and pay, but also stories of racial harassment. The existence of nooses in the workplace in 2014, 2013, 2012, the symbolism of the language used in the workplace. And I understand that there are regional differences where Flake talked about growing up in Texas and Ms. Brown growing up in Baltimore. But what's interesting about this employment discrimination lawyers' work is that some of the worst cases, the most blatant acts of harassment, racial and sexual harassment, I see in the South, but it's not limited to the South. So he has talked about some very egregious cases in the Northeast.
If I can dare say, one of the things that happened recently, and I really hate to bring up his name, but in the report that was issued by the law firm of Gibson Dunn with the Bridgegate stuff, the sexism that occurred in that report is some of the most outrageousness I have seen in a long time. To suggest that the woman who wrote the email was a woman scorned is such harassment. And it was awful.
Yes.
Hi, I have a question. Throughout all of your three presentations, you talked about employers and you talked about legislators. Would any of you care to address employees and individuals in the modern world? Because there, as we've said, people believe that the world is all right, yet we know it's not. What can individuals do today?
Well, I think a simple answer is take responsibility for areas that you know have potential to be greater than they are, but they are not, simply because people have created barriers. And those barriers, in many instances, have been there for a long time. But in some instances, the newer barriers are worse than the old ones. And I think we have to be very keenly aware that change is constantly happening, things are changing, and have a real sense of how we are going to function before it gets to be as problematic as most of the things that we talk about in this session today. We cannot allow that to happen again. We just cannot allow it to happen again. Whether it's our daughters, our sons, or whoever, we have a responsibility, I think, to try to build a means by which they know that they are not going to be discriminated against. They are not going to be put down because of race or color or anything else. And I find that in many instances, there are too many people who are getting away with doing things that they know are beyond the pale of the law, but yet they do them and get away with it. I think we have to take a good look at how we process what's going to happen next, and that's where I am now. It's about what comes next. Do we allow ourselves to be captive by groups, for instance, like the group on the Republican side of the Congress? Do you let a group take control in such a way that all that you do diminishes because they have the power to keep it from happening? And I'm really in a difficult place on that, because I saw Congress that functioned differently in the 12 years that I was there.
You asked, excuse me, what we do as individuals. It's more than a legal issue. It's more than knowing what Title VII says and what the EEOC says. Kennedy referred to it as a moral issue. Johnson referred to it as a moral issue. and it is a moral issue. And I tell students all the time, you are a role model, and you want to be guided by the right moral principles. And if you are, you will be an example for everybody to see and understand that you always try to do what is right.
I think that people think that as an individual you're limited in what it is that you can do. I think that one person can make a difference. I think that where you have an opportunity to speak out about something, if you're kind of in a safe environment, not like the UPS situation where they fired 250 people because they stood up for one person. But when you are, so many times, and I find myself guilty of it as well, because we find that we have to compromise so much in our everyday living. But sometimes, when we have reached certain places in our lives, we become a little bit complacent, and we feel that not as obligated to speak out or to make a statement when we see something that is wrong or inappropriate. And I think that when more people understand that they have certain powers within them that they can do as an individual, that individuals will collectively do more.
Thank you for asking that question. That is a pass the torch question, which is part of the title of the program. And I'm wondering if any of you want to talk to the problem that the new generation to whom the torch will be passed are facing some challenges themselves, whether they are male, female, white, African American, Latino, Latina. The economic downturn has made it difficult to find a job. And so it's difficult to pass the torch to a generation that is consumed with the kinds of problems that our generation may not have faced, with different challenges, of course.
It's a great challenge. Me and my wife had a meeting yesterday with one of our members, a young lady who is out of law school now for 4 years and does not have a job yet. She expected so much more. It is not that she is not going and taking her resume, trying to get a position. I talked to a judge yesterday. I talked to someone in another law office yesterday, trying to get them to at least take a look at her, because she's where we sit because of what we see in her. We see a brilliant young lady, and we cannot find the reason. She says it seems like every time she gets close, she thinks she has it, and she goes to a different place. It's a problem. They're just not hiring certain. I still think they are not hiring certain classes. And I don't know, you're in the profession, so you may know better than I do. And some is dependent upon, and I have come to the conclusion, what school they came from.
Oh, definitely. And the GPA and law review and all of those things.
Yeah,
too.
and she's passed all that. She's done all of that. She's just, but the problem is just finding a job. And she's done some, I guess in law you have certain little small jobs you can get and you can hold on to, and you go there.
And staff attorney jobs.
But that's not permanent.
Right, exactly, and staff attorney jobs are the first people to go.
Yeah.
But one of the things is that, and all of this to me involves access to justice issues and so forth. But one of the things that I also counsel law students is that the world exists beyond the Northeast. And the world exists. Oh, believe it or not, the world does exist beyond the Northeast, and the world exists beyond California, Chicago, and Atlanta. And when you are looking for employment opportunities, there are other places that you can look at. Other places.
This is really good advice.
There are other places that actually need lawyers, and need lawyers in areas of practice of law that are emerging, such as energy. And my position is that you can go anywhere and live for a couple of years, gain important marketable skills, and then come back to the almighty Northeast, where you can use those skills. And they have places that actually have billboards up saying that they are looking for lawyers in these United States. So I think that students have to be a little bit more flexible. I'm not saying that there's a lid for every pot. but there are certainly other opportunities that exist beyond what I call the four corners. Also the world is extremely global now. There are probably opportunities where you can use your JD degree outside of the United States as well. Gain some experience somewhere else and come back to where you want to be. It'll still be here waiting for you.
We have a couple of minutes for more questions. I thought I saw a hand on this side. Yes.
So in 2012, there was the Second Circuit case, Townsend versus Benjamin Enterprises Incorporated, which had, which in my opinion seemed to be a classic retaliation case. But the Second Circuit didn't think so in terms of saying that the protection wouldn't extend to internal investigations since there wasn't an EEOC claim attached to it. And so I was wondering if that decision in any way impacts the way that you advise your management clients.
That's to me, I guess, in some
Yes,
practice
sorry.
what I did. It's not different than what I would always advise them in areas of retaliation, because I have always viewed retaliation as an act that is separate and apart from everything else. Even if some underlying act of discrimination did not occur, you can still retaliate against someone, and I ask people to be very mindful of that, notwithstanding any law that is passed or any court decision, that it's still a serious issue, that even if something is perceived as someone doing a particular thing and then adverse action is taken against that person as a result, it's inappropriate.
I have the unenviable task of closing the single best plenary panel I've heard in 32 years. And I thank all of you. I'll ask the panel to stay as is. We've passed the microphone and the torch to the new generation, most fittingly to May, and small world. About 2 weeks ago, a friend of mine at the Catholic Worker called me up. She's on our board, Jane Salmon, the successor de facto to Dorothy Day. And she said, "Dave, don't you know April 4th is," I said, "the anniversary date of the assassination, the martyrdom of Martin Luther King." And Leonard Baines took the lead on a fine essay I was asked to sign on to in the materials. So we did this fully and deliberately. We held the moderator's position for this panel open for several weeks. And a lot of very prominent folks beyond St. John's wanted this slot. And when Leonard and I got together and we had to decide, we're now so close we complete each other's sentences. And boom, it was none other than Professor Wade. And we could not have had a better choice. The question's equally fine. Martin Luther King, Dorothy Day, Joe Hill said, "Don't mourn, organize." And in terms of organizing, passing the torch, student scholarships here, we're ranked #1 in the country. We have more grants and more scholarships to students after their first year than any other school in the country. And a person instrumental in adding to that is my friend and colleague and co-teacher of employment discrimination, David Marshall. And he said to me some weeks ago, "You know, this woman at my firm, she's the president-elect of the American Bar Association." I said, "Well, what's she doing on April 4th?" And here we are. And David was invaluable in planning this conference. And then he said, "St. John's need not send me a check for any of my work. He's teaching for free." He said, "But I'll take the money they would pay me and I'll put it to a student prize in honor of my law firm, and especially really de facto in honor of the president of the ABA. And we have our first winner of the Edwards, Wildman, and Palmer Prize for the best student paper this academic year in labor and employment law issues, and that's Ralph Carter. And there are a number of other prize and scholarship winners in the audience. I asked Ralph to come up here. David, the microphone and the floor is yours to say a few words, and then we'll hear just a bit more from the president. And see everybody at lunch, but don't move yet. We have a few more minutes to go. But pick up our info around, and you'll see who our scholars are. So if the prize winners could come down here, stay right there, Ralph. David, the floor is yours.
Thank you, Professor. Professor, you'll be standing a while. Paulette's going to be. Good morning. It really is an honor for me, and I owe Professor Gregory and St. John's a debt of gratitude for allowing me to become a part of this really singular community of scholars and students and alumni. I think the extraordinary diversity of the St. John's community bears living witness to the fact that Title VII was incredibly wise in its recognition that if we encourage everyone to express to the fullest extent their talents, we will all benefit from that expression. And we were helped in no small part in the achievement of that goal by the steadfast efforts of the members of the panel here today. Among them is Paulette Brown, who I'm proud to call my law partner and my friend, and who graciously accepted my request that she come here and present the award to the student who wrote the best essay about a contemporary civil rights issue, Ralph Carter, who happens to have 2 years ago won the award for the best exam in the employment discrimination class that Professor Gregory and I teach. So it's quite a terrific honor for Ralph, and I'm pleased to be part of that. Let me tell you why I picked Paulette Brown to give this award and why I'm pleased she accepted. And that is, Paulette and I are partners in the Labor Employment Practice Group at Edwards, Wildman, Palmer. So we spend a lot of time together in meetings. We work together. Paulette is fearless and frank. In those meetings, she is never afraid to ask the question every other partner in that room wants to ask, but they won't do it. She is never afraid to express a dissenting opinion, when the majority opinion is one that she thinks is misguided or misinformed. And she is always prepared to defend the defenseless regardless of the cost to herself. Now, what does that have to do with Title VII? Well, let me round out a little bit about Paulette's biography that you heard some about this morning, but I want to give you a little more detail. As Paulette said, she was born and raised in Baltimore. Baltimore at the time was a quarter African American. Even though African Americans made up such a substantial part of the population of that city, African Americans were not permitted to go to the downtown Reed's drugstore to get a cool drink on a hot day. Paulette wasn't permitted to walk her dog in the public park that was down the street from her house. And as she mentioned, she went to racially segregated schools. Now, despite that official and unofficial attempt to stigmatize, oppress, humiliate people of color like Paulette, Paulette wasn't intimidated. As you heard already, when in light of the Title VII's passage, the city of Baltimore decided to create a fabulous new high school with all the bells and whistles and best of equipment and facilities, where the superintendent was going to send his kids, Paulette found out. Paulette didn't stay within the safe zone of her traditionally black schools, where she would have been with her friends and the other members of her community. Instead, she applied and got a position as one of the few African American students in that high school. And despite the fact that that high school wasn't particularly supportive of Paulette's college ambitions, she made her way to Howard University, where she became an officer in what is a very influential sorority called Delta Sigma Theta. What is incredibly impressive, in my view, in addition to that post, is that Paulette, as an undergraduate, marches herself down to the Department of Health, Education, and Welfare. Many of you may not be familiar with that title because it doesn't exist anymore. That department was such a huge part of the government that they split it up into 3 different parts. But at the time Paulette applied for a job there, it was one of the biggest departments, if not one of the biggest departments in the United States government. She got a job in the bowels of that bureaucracy. She was there for 1 week. She said, you know, I don't think this is the place that really expresses my talents or it allows me to build those skills that I want so much. I'm going to march right up to the secretary's office and I'm going to get a job in the secretary's office just a few feet away from the secretary of HEW. And she got it. And she worked there for a year before she graduated from Howard, accepted a full scholarship to Seton Hall Law School, moves up to Newark, which, quite frankly, at the time she moved up to Newark, was a dangerous, daunting, overwhelming, scary place in many respects. And Paulette, having no connection to Newark whatsoever, marches herself after 2 or 3 weeks of settling in at Seton Hall Law School to the mayor's office of Newark and says, I'd like a job here, and gets one as a policy analyst for the mayor of the city of New York. From Seton Hall Law School, she becomes the first African-American female lawyer in the in-house legal department at Prudential Life Insurance Company. From there, she founds her own law firm, which she runs with for some like-minded partners for many years. She then folds that practice into what has now become known as Big Law and a big law firm. In the meantime, while doing all of that, she becomes president of the National Bar Association. As president, she leads a delegation of American lawyers to be the election observers at the first post-apartheid election in South Africa. That's the election that elevated Nelson Mandela to the presidency of South Africa. And at the same time she is doing all that, she is raising single-handedly a fine young man who is today an aspiring actor, technologist, and Paulette will tell me afterwards the latest vision he has for himself in his career in New York City. But a really nice young man. So what does that have to do with Title VII? Well, the persistence, the stamina, the grit, the determination that Paulette showed certainly doesn't come from Title VII. We'd all acknowledge that. What does come from Title VII is that, and it's directly traceable to Title VII, and I think Paulette earlier acknowledged it, my law firm and my partners would never have the benefit of Paulette's talents and skill and energy but for Title VII. More importantly, many of the people with talent, skills, and abilities like Paulette wouldn't be able to share those with all of us in every part of this country, in every walk of life, but for Title VII. It is because of Title VII that we are all able to benefit from those skills, abilities, and talents. And so it is fitting that today we memorialize the anniversary of Title VII's passage by praising it, by making sure that we preserve its gains, and by paying the benefits forward to the next generation. Title VII isn't some kind of welfare program from one group of citizens to the other. Title VII is actually a gift from all of us to all of us. And I think Thurgood Marshall said it best when he said, in acknowledging the humanity of all human beings, we pay the highest tribute to ourselves. So it's in that spirit that I'd like to turn this podium over to Paulette Brown and to ask her to announce the Edwards Wildman Palmer Prize for the newest member of the community of civil rights lawyers. Thank you.
So if you saw me walk down here, that was your imagination. I actually floated on air after David's, or I guess to say Professor Marshall's introduction. I have to say that maybe a little license was taken with some of that, but I am very, very pleased to be here. I'm very honored that David asked me to present the first Edwards Wildman Palmer Award. I did have an opportunity to read Mr. Carter's paper. I really did read it. And I found it to be a most interesting take on Title VII. And I have to tell you that when New Jersey first proposed the social media law, have you all read his paper? Anyway, you'll read it later, but I can tell you that when New Jersey first proposed its social media law, I thought that from an employer perspective, it was so broad that it caused me to write an op-ed in the New Jersey Law Journal about it. And because it gave rights to applicants as well as people who were already employed, and it also gave specific performance rights. So my theory was, if a person applies and they don't get the job because theoretically they were asked for their social media password, do you now have to hire the person, even if maybe you didn't want to hire them in the first place? And so, you know, I thought that was just wrong, and that it was just too broad of a law to really even be enforceable. And so then I read Mr. Carter's paper, and I got a total different perspective on passwords and social media, and how Title VII can be circumvented by getting the password, how they could find out about people's background and find out what the ethnicity is and all sorts of other things about them, and how they can use that as a means to violate Title VII and use it as a pretext for not hiring someone. And so I would just like to commend you for that very creative thinking, and just really, I don't like to say out of the box because that's so passé, but just thinking in an extraordinary way that made me rethink how I think about passwords and social media, and how people are able to use it in a way that is not helpful to anyone. And so I would just like to ask you to come up, Mr. Carter, and congratulate you personally. I understand the check is in the mail. That's like, I'll be right back. Thank you. Congratulations in the very best way. Thank you. Thank you. All right, good. Thank you. All right.
David asked me to inform you that we're serving lunch, but I also want to commend Ralph. I worked with him on his note. He's part of his notes and comments editor of the Journal of Civil Rights and Economic Development. And I feel like the proud papa of helping birth this note. We had gone through several rounds of edits and drafts, and Ralph has been in my Bizarre class. He was in the journal class. I'm very proud of his accomplishments. So I want to congratulate him as well.
If I may just say a few words, thank you so much, Professor Baines, Professor Gregory, Professor Marshall, and of course, President-elect Brown. I just want to really also thank Professor Costello, who's not here today, for her work for JCRED. Without all of the guidance of everyone here, I would not have been able to make my note, get it to where it is, and particularly, again, Professor Gregory. And that really is it, other than just to say, hope my note can contribute a little bit to the discourse around ensuring that social media is not used to squelch or squash people's ability to speak in open fora, and also it doesn't serve as a means to circumvent intentional or unconscious discrimination in the workplace for employees or applicants. Thanks again, and really am honored to be here.
When you throw the proverbial pebble into the pond, you don't really know where things are going to end up. And this prize has already yielded some great returns. I'm going to ask Courtney Chickfack to come down. And one of our great alums, an evening student, middle of the class, Mike Van Aken, is the Vice President of Human Resources for Coca-Cola throughout North America. And he said, could I establish one of these? And I said, well, sure. And his statement is so profound, I think it bears reading aloud. So Courtney is our first ever Van Aken Prize winner for a terrific paper called Women Warriors. And if you could just read Mike's statement.
So this is from Mr. Van Aken, and I quote, I want St. John's to understand my motivation to honor Richard J. Van Aken in addition to Richard just being my dad. He earned both a BA and MA degrees in criminal justice at night at John Jay College of Criminal Justice while working as a transit police patrolman. I guess being a night student runs in the family. He also worked 3 other jobs at the time, owned a hot dog cart, was a painter, and drove a taxi cab. My dad worked all those jobs to be able to send 3 boys to Catholic school in Brooklyn. When he was younger, he didn't understand the importance of education, although he had a brilliant mind. In the late 1960s, he arrested 3 criminals, one of whom was a relative of the head of one of the most powerful organized crime families. They were shaking down protection money, the owner of a cafe in our neighborhood. Despite having his life threatened, he refused to drop the charges and ultimately testified against the men. His dream was to become a professor of criminal justice upon completing his 20 years on the NYPD. He had less than 4 years left, but he never realized it due to his early death at age 36. It was my father's love of the law that first interested me in the law, and he also taught me the value of a great education, Catholic school in particular, and a strong work ethic. I truly earned my law degree for both of us, and this is the best way I can honor my personal hero.
Now, as David instructed, lunch will be served. So please, it will be on the ground floor of this building. So take the elevators, there's 2 sets of elevators, one set right outside this door, and the other set sort of going down the hallway. So I'll see you there. We have a great treat of the chair of the EOC, who will be our keynote speaker. So we really appreciate her coming, and we want to hear her wise words of wisdom. So thank you so much.